Let's look at a key case in tort for the area of negligence, looking at the breach of duty. This case is Paris and Stepney Borough Council, and it was heard in 1951. This case concerned Mr. Paris and his employer, the council, as he worked in a garage owned by them. The council were aware that Mr. Paris only had sight in one eye. Whilst he was undertaking his work in the garage, a chip of metal entered his eye from which he could see, and it rendered him entirely blind. No goggles had been provided to Mr. Paris, despite the risk of eye injury in the work that he was carrying out, because the council were not required by law at the time to provide any such goggles. Despite what the council stated, that there was no legal requirement for them to provide goggles to Mr. Paris to use whilst carrying out his work, they were seen to be liable for the injuries caused to him. They were aware of his existing visual impairment, that he could only see out of one eye, and therefore it was regarded as reasonable for them to take higher precautions and to provide him with goggles. The seriousness of the consequences in Mr. Paris's case, that an injury to one of his eyes could render him entirely blind, was so much that a higher standard of care was expected from the council where a serious injury is foreseeable, as was seen in the work that he was carrying out. Therefore, the garage breached their duty of care by failing to provide any additional safety features such as the goggles. This case is useful when considering how much care the reasonable man may take, and you can use it when looking at the seriousness of consequences to show that a higher standard of care is expected from defendants where a serious injury is indeed foreseeable.